Before we start, I should say that the court is ordering that until further order, no one shall publish or reveal the name or the address of the appellant, the subject of these proceedings, nor should anyone publish or reveal any information which would be likely to lead to the identification of the appellant or any member of his family in connection with these proceedings or in connection with the related criminal or reporting restriction proceedings. And if anyone is in doubt about this, copies of the order can be obtained from the court staff. Mr. Barker.
I'm grateful, my Lord. May it please the Court, I appear with my learned friend, Ms. Reddy, on behalf of PNM, the appellant, and my learned friends, Mr. Miller, of Her Majesty's Counsel, and Mr. Wolanski appear for the respondents. My Lord, I'm going to take a lot as read, as I'm sure you'd hope, in relation to the skeleton argument.
Yes.
And I'm going to dive straight in with some preliminary observations which we feel need to be made. And if I can ask your lordships, and I'm going to take the reference at electronic page 96, which is in the respondent's case. As the concluding paragraph.
Yes.
Where my learned friends say, this case exemplifies nearly all of the concerns rightly identified by the Judicial Committee in Re S. An adult with the resources to do so, rather than a vulnerable child, has brought High Court proceedings against the press to restrict reporting of an important criminal trial. Now, we lay down a marker at the outset. This is, we say, a misconception which has crept into the heart of the respondent's approach to this case from the beginning. The essence of the appellant's case is as set out at page 67, which is the case for the appellant, at paragraph 18.8. In essence, A is not concerned and never has been concerned to prevent court reports per se or the reporting of the criminal trial, but to prevent the publication in any report of information apt to curtail his and his family's Article 8 rights. And it's important to observe at the outset, your lordships have the timeline from the statements of facts and issues. The Jamil trial at the Old Bailey began in January of 2013 and concluded, as we know, in terms of the evidence and the verdict in May of the same year. And I think it's common ground that both newspapers and indeed other sections of the media extensively reported the Jamil trial right up until the conclusion. But we say, for forensic and presentational reasons, it has always suited these respondents to present the appellant's application as it originally was before Mr. Justice Tugendhat in this way, in order to present this case as being only and squarely concerned with an attempt to subvert the open justice principle. Now, the decisive factor, as we're on page 67, and as was observed in K versus News Group newspapers, which is the case cited there, the decisive factor is the contribution the published information makes to a debate of general interest. So the focus should be on the published information and not the mere fact of a report of court proceedings of themselves. We say that's part of the vice that the first instance judge fell into. It's not enough to raise the talisman, well, this is a court report, and all court reports effectively involve a contribution to a debate of general public interest. One has to focus on the actual information and what contribution that will make. And we say when the court is making an inquiry into this issue, that's to say the issue of the contribution that will be made, this involves ensuring that the open justice principle is legitimately engaged and isn't simply being invoked as a contrivance to rubber stamp what would otherwise be the unjustifiable publication of information that would involve a breach of a party's Article 8 rights. And I'll say that because it's important to bear in mind from a factual perspective, and I'll take your lordships to some of the history in the core bundle. But it is important to bear in mind that at the outset, the respondents were not seeking to publish just another court report about the trial. What they were seeking to do was to run a freestanding follow-up story on the back of the appellant's arrest over a year earlier. And your lordships will have in mind that the appellant had originally been arrested in March 2012. The trial started in January 2013, but he was originally arrested back in March 2012. In other words, the news interest, so far as both these newspapers were concerned, the Times and the Oxford Mail, was effectively to put the appellant in the frame as another potential paedophile suspect in this lamentable saga of the paedophile ring that was effectively operating in the Oxford area and which led to the Jamil criminal trial at the Old Bailey. Now, my lord, as we're on page 67 and the specific issue that the court is concerned with, it's as well to look again at the footnote number 9 on that page, which is a relatively recent judgment of a year ago in the case of C against the Justice Secretary. And I won't read out, but perhaps I will just read out. These are observations made by my lady, Baroness Hale, in that case, where she analysed the open justice principle and picked out, of course, that there are two distinct elements. As she said, quote, "The first is that justice should be done in open court, so that the people interested in the case, the wider public and the media, can know what is going on. The court should not hear and take into account evidence and arguments that they have not seen or heard. The second element is that the names of the people whose cases are being decided and others involved in the hearing should be public knowledge. The rationale for the second rule is not quite the same as the rationale for the first." Now, I'll come back to that decision when I come to review the authorities in due course, but it is important to note those two elements. Now, as to the first one, we would say, in terms of a broad sweep, a court report of the Section 4.2 proceedings that took place before His Honour Judge Rooke at the Old Bailey can easily be written and reported without identifying PNM, the appellant, to paraphrase my lady Baroness Hale, so that people interested in the case and the wider public can know what is going on. Now, as to the second element, and as we'll see when we come to look at the evidence put in by the respondents and the way as we say, the sands have shifted in terms of what they were proposing to publish, the only rationale that's advanced for publishing what I would call the identifying details is in essence that such details enhance the reader's engagement by adding colour. That's the
this is Lord Rogers.
It's Lord Rogers. It's what's in a name principle, and that is for understandable reasons an observation made by Lord Rogers that always echoes in the submissions made by media respondents in these situations. Now, we say that it's that need, not the need to ensure that readers understand what is going on, which must be balanced against what we say are the potentially devastating consequences of overriding PNM's Article 8 rights in this case. And I add as another observation, which we say is important at the outset, it should not be forgotten that PNM became the subject of the Section 4.2 proceedings in the Old Bailey in the course of the Jamil trial by a side wind. He was not one of the accused. He was not a witness, and so was not the sort of party who could expect to endure the inevitable, one might almost think, save in the most exceptional cases, intrusion in his Article 8 rights of the kind that we've seen referred to, for instance, in the Kime-Todmer case, which is referred to in Ries and which is set out there. Now, having set out that background, and indeed particularly emphasising the court's inquiry in seeing, well, why is the open justice principle being invoked, we say it's important to look at precisely how it was and what it was that the respondents were seeking to publish at the outset of this saga. And I'll start the narrative, if I may, with the two emails that were sent in May 2013 by each set of respondents. Now, this is in May 2013, which, as your lordships will appreciate, as the trial was beginning to come to an end. I'll take the first, which is at page 460, part of the appendix. This is a email from the fourth respondent, Mr. Wilkinson, the reporter. He says, addresses himself directly to a PNM. As the Oxford child sex exploitation trial draws to a close, we are considering running a story on your arrest in March last year, when the case concludes. It's page 460. There are then references to aspects detailing information concerning PNM, which I won't read out, but it said that his arrest is of public interest for those reasons. And he says, I should say that we are fully aware of reporting restrictions and will act accordingly. However, it's only fair that you have the right to comment in the paper when and if the story runs. If you want to say anything, please do get in touch. The best way would be an email and so forth. So pausing there, no suggestion there that all they were concerned to do was run a court report or informing readers about the issues raised by Section 4.2 proceedings and anonymity. This was quite squarely a story that was contemplated relating to the arrest in March of the previous year. And indeed, you would not need, we say, to have any comment from the appellant if all that was contemplated was a court report. Interestingly, there was an awareness there of the reporting restrictions, and they were anticipating acting accordingly. Now, over the page, at page 461, you will see the email sent on the 14th of May. Now, again, I don't think this is controversial. This was very shortly before the verdicts were were expected. And again, I can just take that fairly briskly.
Yes.
Information, the intention to report details, we say, have nothing to do with the criminal trial itself. I'm not going to read any of the material out. And this contains, and I'll give your lordships the reference without going there, there are two pieces of information that are included in that email. The cross-reference for that is paragraph 25 of Mr. Justice Tugendhat's judgment. That's at page 123. I'm not going to go there now, but it's recorded by the judge at first instance that amidst the information that is set out by Mr. Norfolk, who is the second respondent, there were two pieces of information which the counsel, then acting at the criminal court on behalf of the appellant, contended must have been submitted to the press by the police. Now, it's telling, we say, that neither respondent was ostensibly concerned by the Section 4.2 reporting restrictions and was at that stage apparently content to abide by them. One can infer that this was because the proposed reports, they were not in any sense contemplated as reports of the criminal trial itself, but still less reports of the Section 4.2 proceedings. Now, in fact, and the timing of the dates important to have in mind, email was sent on the 14th of May. The Times had already made an application to Judge Rook on the 8th of May to lift the Section 4.2 reporting restriction already in place. Again, I won't go there, but the cross-reference is referred to in paragraph 17 of Mr. Justice Tugendhat's judgment, and that's at page 121. And so we have the email sent on the 14th by Mr. Norfolk, and the following day, the 15th of May, was when a learned friend, Mr. Wolanski, appeared on behalf of the Times, I think, before His Honour Judge Rook. Now, at that hearing, the Crown supported the continuation of the Section 4.2 order. The cross-reference for that is Mr. Justice Tugendhat at paragraph 26, page 123 of the electronic bundle. And then the following day, on the 16th of May, Mr. Justice Rook gave a ruling refusing to discharge the Section 4.2 order. Well, what he ruled was that it would remain in place until a charging decision was made concerning the appellant, but that if no decision was made by mid-September 2013, then he would review the position at the end of that month. And the cross-reference for that is Mr. Justice Tugendhat at paragraph 27, bundle page 123. Now, as your lordships know, on the 25th of July 2013, the police notified the appellant by letter that he was, I'll use the phrase that criminal lawyers use, he was de-arrested, rather ugly word. Effectively, he was to be released without charge, but that the case would be kept under review. That's referred to in paragraph 31 of the first instance judgment. That's page 124 of the bundle. So that's July. And on the 25th of September 2013, as anticipated, the matter duly came back before the Judge Rook, for oral judgment following the exchange of written submissions. Again, cross-reference is para 32 of the first instance judgment. That's page 124 of the bundle. The respondents again argued that section 4.2 should be discharged. The prosecution agreed that as the appellant was not facing any pending or imminent proceedings, there was no basis in law for its continuance. Now, there were further submissions, written submissions exchanged into early October. And I don't know whether I've given the reference to the 25th of September. That's paragraph 32. Well, I've given it already, I'm grateful. Now, that takes us to the 4th of October. That date's important. That's paragraph, again, referred to in the Tugendhat judgment at paragraph 34, page 124 of the bundle. The 4th of October was the date on which the appellant notified these respondents of his intention, absent appropriate undertakings, to apply for a privacy injunction to prevent his identification in relation to the police operations which had led to the convictions in May. Now, pausing there, we say, and we contend, that it was the threat of that application for an injunction, and only that threat, that led to the subsequent change of tack by the respondents. They clearly put their heads together, and they wrote letters to the appellant solicitors in substantially identical terms. Now, if I can ask your lordships to look at page 463 of the bundle. That is a letter from Miss Burge, who is an in-house lawyer at Times newspapers.
Yes.
And I just so your lordships can compare, there's no dispute about this, but there's a letter written in virtually identical terms by Mr. Westrop on behalf of the Oxford Mail publishers, NewsQuest. That begins at page 465. But they are in near identical terms. But I'll stick with Miss Burge's letter.
Yes.
And you'll see that from the third paragraph, it said that third paragraph, no undertakings will be provided. It's TNL's wish to report the court proceedings concerning the imposition and lifting of the order under section 4.2 of the Contempt of Court Act 1981 relating to your client. These proceedings concern issues of considerable public interest, including A, the position of individuals about whom allegations are made during court proceedings who are not parties to those proceedings, B, the extent of the protection from publicity given by law to those who are facing imminent or pending criminal proceedings, and C, the challenges of reporting criminal proceedings where such issues arise. We consider that the recent proceedings involving your client, during which these issues were carefully explored in open court on several occasions in respect of which a detailed ruling was handed down, provide a very vivid illustration of how these issues are treated by the courts. It's our wish to explain these proceedings fully and fairly. We wish to identify your client in our reportings, since this would make the piece considerably more engaging and meaningful for our readers. So there we have the what's in a name invocation for identifying the appellant. As you may be aware, the Times has for many years taken a close interest in issues concerning open justice, has considerable experience in reporting such cases in a responsible and lawful way. A fair report of the proceedings concerning your client will of course have to make clear that he has been released from police bail and is not facing imminent or pending proceedings. We hope that this will go some way towards alleviating your client's fears, as explained in his witness statement. Any undertaking or injunction in the terms you seek would prevent TNL from publishing such report. If your client seeks to apply from these terms, TNL will resist the application and so forth. Now, it's interesting, we say, despite the emails that were sent in May, And notwithstanding the imminent likelihood of the Section 4.2 order being discharged, respondents were now claiming that all that they wished to report were the court proceedings concerning the imposition, lifting of the Section 4.2 orders. And it's on that basis, tellingly, we say that it's asserted that an undertaking or injunction would prevent the respondents from publishing such a report. This is harking back to the point I made in opening about the court need to inquire very closely that the open justice principle isn't simply invoked as a joker or as a talisman to fend off any attempt to prevent the publication of otherwise private information. The justification for identifying the appellant in what was supposedly going to be, from that description we've seen, a decidedly specialist article concerning judicial policy on Section 4.2 orders, was simply, as we've seen, to make the piece more engaging and meaningful. And we submit and suggest that the court is entitled to infer that this inexplicable narrowing of the reports originally envisaged the previous May was a deliberate decision in the hope of thereby being able to pray in aid and seek the otherwise unavailable protection of the open justice principle. Now, we say that a real concern for the courts, and particularly to somebody in the position of this appellant, is that this way of proceeding allows the open justice principle to be deployed as a legal Trojan horse, which would permit, in this case, the appellant to be publicly exposed under the guise of a court report as a man arrested in connection with Operation Bullfinch. That was the police operation by the Thames Valley Police, which gave rise to the trial at the Old Bailey. At a stroke, such a deployment of the open justice principle would firstly eliminate any future prospect of the appellant asking the courts to protect his privacy rights in relation to the arrest by placing it in the public domain. And secondly, and importantly, thereby paving the way to an open season to the kind of reports originally contemplated in May 2013. And one of the criticisms you'll see that we've made of the judge at first instance was the fact that he was prepared to accept at face value the simple assurances by the media that all they were proposing at that stage to publish were Section 4.2 court reports of the kind we've just seen outlined in the letters of the 8th of October. But that is to ignore, we say, the Trojan horse element, because, of course, editorial imperatives change. And once the cat's out of the bag, who is to say what will then follow? Put another way, once the court report has effectively identified the appellant as somebody who was in the frame as a suspect for the purposes of the police investigation, there's no reason or no basis one can see for restraining other sections of the media from doing follow-up pieces of the kind that were flagged in the May emails. Now, to return the May 2013 emails, now to come back to the timeline, on the 14th of October 2013, His Honour Judge Rook circulated a draft ruling. That's at page 4. I'm not going to go there, but it's at page 473 of the electronic bundle, in which he was proposing to discharge the order. Now, there's a curiosity here, which may be down to practice at the Old Bailey. In fact, the ruling was never handed down. It remains the case, in fact, that the order has never been discharged. This was a point that Mr. Justice Tugendhat made at paragraph 33 of his judgment, which is at page 124. So that was the ruling that was circulated on the 14th, but the very next day, on the 15th of October, is when the hearing before Mr. Justice Tugendhat took place. Now, can I ask your lordships to look at the skeleton argument, which begins at page 165 of the electronic bundle?
Yes. Yep.
And it's really just two paragraphs I'm going to ask your lordship to look at. One is paragraph 6 on page 167. Perhaps I would start with paragraph 5, because it and I'll be coming to those, and I'll take them fairly briefly as well. The respondent skeleton says there are witness statements on behalf of the defendants from Mr. Smith, on behalf of the first and second defendants, Mr. Wilkie and Mr. Wilkinson, and then this in paragraph 6. In summary, the defendants wish to be able to report the arguments and rulings in open court concerning the imposition and lifting of the Section 4.2 order relating to C, which they consider to be of high public interest, and consider that editorially such reports should include the identity of C. And then for completeness, if I can ask your lordships to go to page 173 in the skeleton. Lordship will see a long paragraph 25 with lots of sub-paragraphs. Paragraph 25 says, against all this, the court must balance the very significant public interest in permitting the reporting of the open court proceedings concerning the Section 4.2 order. And I'm not going to read all that out, but your lordships will see at paragraph 25.3 in particular, it said more specifically, the arguments and rulings in this case raise very real questions of public interest, as identified in the witness statements of Mr. Colley and Mr. Smith. As Mr. Colley puts it in paragraph 14, as Judge Rook recognised, this raised important questions about how the courts and press should report such matters while the police investigation is continuing. So pausing there, for the first time before, we have before Mr. Justice Tugendhat, the narrowing of the proposed ambit of reporting flagged for the first time in the 8th of October letter in response to the threat of an injunction application. What is now said to be contemplated is purely a report about the arguments and rulings. For completeness, I can take fairly briskly the witness statements that were put in by the respondents. The first is at page 448 of the bundle, which is the statement of Mr. Smith. And so, I'm not going to read all that out now, but just so you have it in paragraph 1, he's the head of news for the Times. I'm just going to cherry pick the relevant parts of the statement. Paragraph 12, he says, having followed the case in detail and having been involved in the hearings concerning the imposition of the Section 4.2 order, the Times considers that this particular case raises real issues about open justice. The story concerning PNM has, and then I'd emphasise these words, therefore moved on from a mere report of his arrest to a story about the legal proceedings concerning the imposition of reporting restrictions. This is a story which is of considerable interest to us and in which we believe there to be a genuine public interest. Pausing there, the reference to moving on from a mere report of arrests, words which we say suggest that a report of the arrest was still in the frame, the suggestion is that the caravan had moved on and it was now about simply about the reporting the Section 4.2 proceedings. And again, you'll see paragraph 14, the paragraph that was cited in the skeleton. The Times doesn't wish to report anything concerning PNM, which has not been said in open court. Its desire is to be able to report the proceedings surrounding the imposition, maintenance, and ultimate discharge of the Section 4.2 order in the Jamil case, because it raises important issues about the Article 10 rights of the press to be able to report matters of public interest, such as the basis on which the 4.2 order was made and the reason why it was lifted. It's also the case that the publication of such reports may encourage other witnesses to come forward, including those who might be able to rebut allegations against someone who has been unfairly identified as an alleged offender. So there we see creeping in an alternative justification for the identification of the appellant, claimant as he was then, that it might encourage other witnesses to come forward. It is ironic to note, and again I don't think this is contentious, but that during the trial, the Crown opposed the identification. I think I've mentioned already, the prosecution opposed the lifting of the Section 4.2 order precisely because it would interfere with lines of inquiry that were taking place. So again, one has an example of a rather formulaic invocation of public policy reasons why it might be appropriate to name or identify somebody in the appellant's position. Moving on quickly to the, perhaps before we leave the Times, it's perhaps telling, we say, there was no witness statement from Mr. Norfolk, the second respondent, saying that so far as he was concerned, you'll recall he was the one who sent the email back in May 2013, that a court report of this kind is all that he wished to publish. Now, we say that's important having regard to the Trojan horse factor. Of course, we say, had it been possible for the respondents to identify the appellant in their Section Court 42 reports, we say there would have been nothing to stop Mr. Norfolk returning to the fray and publishing the kind of story that he foreshadowed in his 14th of May email, because by then, as I've said, the cat would have been out of the bag and the identity of the appellant would have been out there. Now, we then have the statement of Mr. Colley. That's at page, means flipping back. It's page 356 of the bundle, if I'm not mistaken. It starts at, I beg your pardon, it's 454. 454? I'm grateful. It's 454. I've given this the page number to the appendix.
454.
454, the first page of Mr. Colley's statement. Again, I'll take that briefly. He's the head of content and the assistant editor at the Oxford Mail.
Okay.
Paragraph 12, again, we can take briskly. He says it's our job to report dispassionately and objectively on all matters that we can lawfully publish. That includes reporting judicial proceedings where the charges result in either convictions or acquittals. Equally, it includes reporting on issues arising out of the proceedings. In this case, the arguments which have been made in open court over whether or not the applicant should be identifiable, given that he had been arrested, are of very real interest to us and will be of very real interest to our readers. This is something we wish to report upon and which we believe should be able to report upon, given the arguments that were ventilated in open court. Consider that any such reporting would be very much brought to life for our readers by identifying the applicant. And then paragraph 14, it follows that we consider it important to report openly the applicant's dilemma in finding himself apparently referred to in criminal proceedings while under investigation in connection with similar allegations. As Judge Rook recognised, this raised important questions about how the courts and the press should report such matters while the police investigation is continuing. So we seem to be straying, so far as the Oxford Mail is concerned, not just to the arguments and submissions made in the Section 42 proceedings, but to have a colour piece about the appellant himself and the dilemma he found himself, to use the phrase I used in opening, being brought in by a side wind into the spotlight, potentially as a result of the Section 42 proceedings in the course of a notorious criminal trial involving the gravest imaginable allegations. Again, we say it's perhaps telling that there's also a statement at page 452 from Mr. Wilkinson, the fourth respondent, who's the journalist, the reporter on the Oxford Mail. Again, I'm just going to focus on what he says at paragraph 6, where he refers to the email he sent back on the 7th of May of 2013. He says, I sent an email to that's on page 453, paragraph 6. I sent an email to the applicant about running a story about his arrest in March 2012, since the child exploitation trial at the Old Bailey was drawing to a close. I was hoping to have his comments in the story if we did decide to run an article, but bearing in mind that the Section 42 reporting restriction was still in place. I didn't get a response from the applicant. We did not run the story in any event. And again, I just say in passing, it's perhaps telling that Mr. Wilkinson doesn't in his witness statement say in terms that he no longer wishes or contemplates writing the story he obviously had contemplated when he sent the email on the 7th of May. Now, the judgment of Mr. Justice Tugendhat, I'm coming to the end of this narrative, but that was given on the 22nd of October. The judgment starts at page 118 of the bundle. And this included a finding, which is one that you'll have seen from our case and from the argument below, with which the appellant takes issue. That's the finding by the judge, which is at, I hope, page 138 of the electronic bundle.
Yep.
Which is paragraph 82 of the judgment.
Yes.
Where he says, while I understand the claimant's suspicions that the two items of information mentioned above were leaked by the police, I do not find that these points add anything to the issues I have to decide. He says, there is now no threat by the defendants to publish either of these pieces of information, otherwise than as a report of the proceedings in open court. I can make no findings of fact on these points on contested written evidence. There's nothing before me to call into question the denials by the defendants that their journalists have been engaged in any improper behaviour. Well, of course, pausing there, and just so we're all clear, the concern here is not a suggestion of impropriety. It's the use or potential use of the open justice principle as a springboard. And of course, the deployment of the open justice principle would, if the application made to discharge the Section 4.2 order succeeds, or if the appellant's application for an injunction had failed, it would have been a springboard because they could have published and identified the claimant's name, and at that stage, the threat, it's simply wrong of the judge to have said that there was simply no threat because the judge can't know and the courts can't control what editorial imperatives might require in the future once the identification cat is out of the bag. Now, as your lordships know, the appellant duly applied to the Court of Appeal for permission to appeal, and this was duly granted by Lord Justice Law on paper on the 6th of December 2013. That's recorded in paragraph 28 of the Statement of Facts and Issues, where I won't go there, it's page 44 of the bundle. Now, that's important, we say, because the granting of permission to appeal, and thus the inevitability of an appeal hearing, prompted what we contend is a further tactical letter from the respondents on the 11th of February of 2014. That's at page 467 of the electronic bundle. This is from, I think, Miss Burge again from Times newspapers, starting at page 467. Your client's principal ground of appeal, she says, so she's writing on behalf, perhaps I should just observe in the opening paragraph, she's writing on behalf of all the respondents. Your client's principal ground of appeal is that Mr. Justice Toogood had wrongly proceeded on the basis that the respondents would only publish information concerning your client's arrest in report of legal proceedings. In support of this ground, you seek to argue that in the absence of binding undertakings to the court by the respondents, the judge should have given no weight to the respondents' assurances that their report would be confined in this way. This contention is misconceived. The judge was plainly entitled to reach the conclusion that the respondents would abide by their assurances, provided not only in correspondence but also through counsel in court. Those assurances were given in good faith and the respondents stand by them. Further, neither your client nor the judge ever sought any undertaking from the respondents, either in correspondence or during the course of argument. The absence of such an undertaking was therefore irrelevant to the judge's consideration of the issue of whether there existed any threat that the respondents would publish matters beyond mere reports of court proceedings. You have now raised the point about the absence of any undertaking for the first time in your skeleton argument for this appeal. It was not raised before the judge and features nowhere in the judgment. It should not therefore form part of your client's appeal. However, without prejudice to the above, given your client appears to continue to entertain doubts as to the respondent's bona fides, the respondents are prepared to provide an undertaking to court to meet his concerns. They will undertake not to publish the following matters, save insofar as they may feature in reports of legal proceedings protected by statutory privilege, or insofar as they may feature in reports which constitute honest opinion upon such a privileged report under the Defamation Act. So pausing there, we now see an apparent attempt to widen the proposed ambit of what is to be published under the guise of this so-called undertaking. So it's not just going to be a court report of the arguments and submissions and the imposition and lifting of the Section 4.2 order, but also what is broadly described as honest opinion, which we say of itself is, of course, for understandable concern to the appellant, the widening of the goalposts to include not just reports of the Section 4.2 proceedings, but also what was now described as honest opinion, just shows the dangers of courts relying on assurances and the fact that editorial imperatives can change. We would, just the quickest way to deal with our response to this is to look at page 469. I don't know whether you're, again, I'll be guided by the court. Is the court content for me simply to ask the court to read the letter to itself? And
We'll read it later, unless there's
Grateful.
any particular point you want to
No,
take.
I'll simply record.
We have looked at the document.
I'm grateful. It's simply the point that this comes late in the day, and of course the skeleton argument was produced the previous November. But it's all of a piece, we say, of the concerns that we raised at the outset, the Trojan horse element. And we ask your lordships to have this background very much in mind when the hand-wringing inevitably comes by media respondents saying that all they want to do is to publish court reports. It is very much our clarion call in relation to the Trojan horse argument and the concerns that we expressed before the judge at first instance, and why we criticise his decision that the court should not simply treat the incantation of open justice principle as an excuse not to analyse, as we say is now required by the KN News Group decision, to look at the purpose that's served by the particular information. And my lords, I'm not, we're in the very unusual position, and I'm in the unusual position as an advocate, to seek to defend an interpretation of a Supreme Court decision which lies at the heart of this appeal, where Lord Reid gave the leading judgment.
Well, in a way, one's meant to judge a judgment objectively and not subjectively.
Yes.
So one looks at the words.
Yes, but it's...
we all find, particularly people who enter into contracts, later being told that they agreed something and neither of them realised they had.
Yes, well, I'm grateful for that
Maybe
indication.
true of judges on occasion.
There's an element of
We
impertinence.
do it all the time.
Yes.
They analyse our judgments and suggest to us that we said things or meant things that we
Yes,
may or
it's
may
the
not agree with. It's
the
very
first-
common, so don't be bothered about
Well, I'm
it.
grateful for that indication. It's just, I think it's the first time I've ever had 3 out of 5 judges actually reappearing in front of one. So it's an unusual scenario, at least for me, if not
Well, enjoy it while it lasts, Mr.
for Mr.
Barker.
Miller. Again, I think it would be insulting to repeat the nub of the submissions in the case. I'll pick up one or two, perhaps if we have the case open as a point of reference. The case starts, as you'll be aware, at page 47 of the electronic bundle.
Flag?
I'm so sorry, it's... This is no, I don't. I want the... I'm sorry, I'm going to the case for the appellant rather than the A itself at the moment.
Okay.
I'll come to it in a moment.
We're going to go to page 47.
Yes, 47, which is where the case for the appellant starts. And your lordships have in mind that it's really at page 48 where we start the analysis, which is the first ground of appeal as to the way in which A versus BBC unfolds. Now, one of the points we make, one of the criticisms we've made of the Court of Appeal, the nub of the criticism is, effectively the Court of Appeal took, this is the way we characterise the judgment, the position in relation to these issues, that's to say the interplay between Article 8 rights and Article 10 rights, where reporting of court proceedings are involved, was effectively settled by Ries and the Guardian and News Media case, and that the AM versus BBC case really changed nothing. And we say that was a surprising line to take, given that one would normally sit up and listen, whereas here a Supreme Court decision opens, as you can see, cited in paragraph 3 of the case, that the appeal before it, as Lord Reid said, raised important issues concerning the principle of open justice, in particular, issues concerning the legal basis of the principle, the circumstances in which it can be departed from, and the procedures which it should be followed. Now, I don't know whether it would be helpful. Again, one's always sceptical about the value of simply paraphrasing submissions in the skeleton argument. I will go to the A versus BBC in detail if need be. But the essence of what we say is the message to be taken away. We've distilled in paragraphs 7 of our case, starting at the bottom of page 50. We contend that what A versus BBC really does is to really revive, bang the drum, if you like, the need to look at the common law as a first step. So, as we say, firstly, the two principles we distill from A versus BBC are firstly that in any dispute before a court involving both A, the principle of open justice at common law, and B, convention rights, the starting point must be a consideration of A. Pausing there, in Re-S, of course, that was the 2004 case that has now become the totemic case in this field. It was held that the fount of the jurisdiction, it was effectively now Article 8 of the Convention. But we say the importance of A versus BBC is to say, well, that's all well and good, but when you're looking at a principle that derives from the common law, as does the open justice principle, the court should, as a prior step, consider whether any of the common law needs to be developed further, and that in so doing, express regard can and should be had to changes in society, the administration of justice, the differing approach to open justice in the common law jurisdiction, and any other relevant ECHR jurisprudence. Why we would say the case was radical and important, it was saying that effectively matters were not settled forever by Re-S simply by virtue of confirming that the fount of the jurisdiction was now to be found in Article 8 and Article 10 and the Convention. But when one is applying a principle that has its origins in the common law is still a live creature, and it is a creature capable of further growth. Now,
But what difference does that make?
well, this is
Given that the court has got, as a public authority, has got to act consistently with the Convention rights or compatibly with the Convention rights. So what difference does it make?
Well, it makes a difference because the court, by the time it's conducting the weighing exercise between Article 8 and Article 10, is asked to look at, well, what is the open justice principle? And one can see in all the judgments, one has a constant recourse back to Scott and the cases decided since. The prior question for the court to determine, this is why we say A versus BBC is important, because it anticipates a two-stage process. One first has to determine where the common law principle itself has got to. So where has the open justice principle got to at common law? We say it's not only not ossified and set in stone for all time, but it's capable of change and development. And for that purpose, it's legitimate to look at not only changes in society, but also other commonwealth and common law authority.
But the court would then have to ask itself, the common law having got to this point,
Yes.
does Article 10 lead to a different conclusion?
Yes, we don't seek to undermine the Article 8 and Article 10 weighing exercise, and that's ultimately the exercise the court still has to perform. We accept that. But in so doing, it still has to perform what we say is the prior exercise, is to look at the...
Does it come down to this, that you're saying that in A and BBC, this court found a rather different reason from the standard reasons for anonymising a report of court proceedings? One that possibly had to be a bit developed from what the previous law had been. I say only possibly because it seems to me to have been entirely consistent with the need to serve the purpose of the proceedings in A and BBC. So you would like this court to find common law reasons for anonymising this report, which are rather different from the ones that there have previously been. Is that what you're saying?
Well,
and then we can start with that, and then we ask the Article 10.
Because my friends say, of course, we can't interfere with the Court of Appeal's decision or the judges simply because we don't like the result. It has to be an error of principle. We say the error of principle that's evident in the Court of Appeal is effectively to say, as Mrs. Justice Sharp does in paragraphs 38, it might be helpful just to see what the Court of Appeal actually said.
If I can intervene,
Yes.
Something to bear in mind is that in the case of A, the court was having to address a submission that the common law jurisdiction in relation to the open justice principle had been abolished.
Yes.
That it had been replaced entirely by the Human Rights Act, with the consequence that cases like Scott and the Leveller magazine and so forth were no longer of any relevance. One had to look simply at the convention jurisprudence. That was why the court said what it did through my judgment in the paragraphs that you
Yes,
referred to.
no, I appreciate that, and that's where we say, I can distill it down in this way, the vice of the approach of treating it as everything is now down to the convention is to treat the Scott and Scott open justice principle case law as effectively ossified, if I can borrow that phrase. There's reference to an ossuary of the common law, I think, in Canadian Information Commissioner, which we refer to in the case. And that is the vice, and that vice is apparent when one looks at some of the observations made by Lord Dyson below, which we've set out in the case, where he said, well, it's simply not helpful to us to have reference to Canadian authority because they have a different approach and so forth. And the attitude of the Court of Appeal was very much, well, it's all settled law since Re-S. It's the convention exercise, balancing exercise that we need to look at and nothing more. And that effectively discouraged, to put it neutrally, any analysis of whether the open justice principle was still capable of development or updating, to paraphrase my Lord Reed's judgment.
What is the precise development of the common law of the open justice principle for which you contend?
I'll list them if I may. We would say whether in weighing the balance, let's see if I can give us a prompt. I'll answer that question directly, my Lord, but as a prompt, as a starting point, can I also just refer you to our case at page 51 of the bundle? I'm going to use that wording. There's a reference here in paragraph 8.2, which we've said it's Lord Justice Toulson in that case back in 2012 in the Guardian News and Media case against Westminster magistrates, which we say used language in very similar terms to that used by my Lord Reed in A versus BBC, where it said this in relation to the open justice principle: while the broad principle and its objective are unquestionable, its practical application may need reconsideration from time to time to take account of changes in the way that society and the courts work. Unsurprisingly, there may be differences of view about such matters. And we say that dovetails with what my Lord Reed came on to say in A versus BBC.
So are you not proposing to answer my Lord's question?
Yes, I am. I'm going straight to it. In weighing the balance, we say that greater allowance should be made for, firstly, the presumption of innocence, secondly, the real stigma attaching to individuals identified purely as suspects, thirdly, that even suspicions of criminality, mere suspicions, may lead to the taint of guilt in the eyes of some sections of the public. Fourthly, the fact that accusations of sexual offences against children are especially apt to cause irreparable harm in terms of stigma, readiness to assume the taint of guilt and the likelihood of reprisals, and so on. And then fifthly and finally, the growing acceptance, we say as a matter of public policy, that the identity of those arrested or merely suspected of a crime should not generally be released to the public. So they're all interrelated, they dovetail to a great degree. But to paraphrase the Westminster Magistrates case, those aspects of the practical application of the open justice principles are the ones that require particular reconsideration. There are 5 of them that I've just enumerated, and they're all interrelated. Now, my lords, what I was proposing to do, if it assists, having set the groundwork for those principles...
That's very interesting indeed. I'm grateful to you for answering my Lord's question in that clear and simple way. But it sounds to me as if what you're suggesting is that in a very large number of cases, but particularly sex abuse cases, suspects should not be named unless there was a specific reason for naming them.
Well, I
the case?
wouldn't go that far. We'd say it's obviously more likely, given the nature. That's why some of the Canadian authority is helpful. And indeed, some recent first instance decisions I'll come to, such as the judgment of Mr. Justice Cobb in the Rotherham Metropolitan Borough case. We don't ask for a blanket rule. You may have picked up, there's been a recent report by Sir Richard Enriquez, the retired High Court judge, and he very startlingly has come to the conclusion. He was, of course, I'll take your lordships to it briefly, but he, of course, investigated the rather parlous Metropolitan Police investigation of historic sexual abuse allegations concerning various prominent public figures, such as I think, Field Marshal Lord Bramwell's,
we know about that.
everybody else.
Yep.
But he's come to the conclusion that there ought to be statutory protection. Now, we don't go that far, because an easy answer to our appeal would be to say, well, it's for Parliament to decide if it wants to revisit the granting of anonymity to potential suspects or arrestees or anybody else. But we do say that these 5 headings that I've enumerated are matters that ought to be given a greater allowance for when applications are made on a case-by-case basis. We don't seek to argue, perhaps my lady, Baroness Hale, is suggesting that we're seeking a blanket introduction of anonymity for all sex offence cases.
I'm not suggesting it, I'm just
Yes.
asking. Because obviously one of the things that is of some concern, at least to some people, is that rich and powerful people can afford to take cases to court and fight also rich and powerful newspapers, whereas the damage may be done to all sorts of not rich and not powerful people who couldn't begin to think of bringing proceedings in court.
Yes, and indeed that's it's the there's a rather sort of tart reference in the closing section of the case for the respondents about the appellant being an individual with the resources to do it. The other side of that coin is it's a matter of concern that there are lots of people who are just, as you say, not in the position to be able to
But this is why the case-by-case basis, that's why I was pushing you on what the implication. See, you say it on a case-by-case basis. Well, a case-by-case basis tends to suggest a judge decides, weighing these balancing factors.
Yes. But if one starts to have if there is a recognition that these factors are to assume a greater significance than they have in the past, you will eventually start getting, one would hope, starting with the court's decision, a corpus of law that makes it clear that the open justice principle has been revisited, has been recalibrated in the light of recent developments, not least a more realistic interpretation of, for instance, the fact that members of the public are very often inclined to see no smoke without fire, that perhaps the courts have in the past been too willing to assume, as the Court of Appeal did, take it as read, that members of the public understand the difference between suspicion and mere guilt.
Well, some people may have an instinct that you're right, but is there evidence in this case to support that proposition, that there is a general or at least frequent equation of suspicion or arrest with guilt?
Not evidence. Does your lordship have in mind evidence of surveys or the like, or something of that sort? I mean,
we just can't reach back into our feelings about your submissions. And your second and third propositions are squarely put on an alleged equiparation of arrest with guilt.
Well, I suppose one can do no better than to rely on collective judicial experience. And your lordship, perhaps if I can take your lordships to the response of the judiciary to the Law Commission paper, which I suppose is, I'm not sure it amounts to evidence. It's page 410. I was going to come to this.
I suppose you might also say that there is no evidence to support the contrary proposition.
Yes, I mean, I suppose that goes without saying. I mean, I'm not, with respect to my Lord Wilson, I'm not sure that it's a proposition that's capable of being decided one way or the other by evidence. It's more
you're about to take us to evidence.
There won't be a lot of people who, when asked in a survey whether they understand the difference between suspicion and guilt, will say no, whether or not they do.
But even if they do, you still have the next question, which is no smoke without fire type question.
Yes, I mean, it's another side of the same coin.
Well, it's a slightly different point.
Can I ask you to look at the top of page one. We're starting at the bottom of page 411, just so one has the context. Just so your lordships will have looked at this, but this is as you can see, this is
Yes.
this was rather dismissed by Lord Justice Voss during argument down below as just the opinions of judges, but you can see just at the top of page 314, it's the response to a Law Commission consultation on contempt. You have all that, I'm grateful. It's the bottom of paragraph 2.
Thank you.
To answer Lord Wilson's question, reliable law for the contenders to protect the right to a fair trial. The right is breached where before conviction, and it's which is the
If you want your...
it's the top of. I'm grateful to my learned junior. It's the bottom of 316, paragraph 5.
Thank you.
Question 63. A decision by the police to publish the names of a person arrested must be made after consideration of the rights of such persons, including their rights under Article 8, on a case-by-case basis. The police arrest many people who are never charged. If there were a policy that the police should consistently publish the fact that a person has been arrested, in many cases that information would attract substantial publicity, causing irremediable damage to the person's reputation. Even if the fact that the person was not charged was subsequently published, that would not receive the same publicity. It would not prevent subsequent internet searches disclosing the person had been arrested. See Attorney General versus MGN. The case of Christopher Jeffries, who was arrested on suspicion of the murder of his tenant. We adopt the words of Lord Justice Leveson in his report, para 239. The current guidance in this area needs to be strengthened. For example, I think it should be made abundantly clear that where in exceptional and clearly identified circumstances, for example, where there may be an immediate risk to the public, the names or identifying details of those who are arrested or suspected of a crime should not be released to the public. It may be that the civil law should be reformed to give a remedy for the publication of prejudicial information in addition to the law of contempt, but that is beyond the scope of this consultation.
Is that all a quote from Lord Justice Leveson? I don't see any ending inverted commas, so I think we should be, forgive me for being pedantic.
No, I think that is right.
We should understand whether that is Lord Justice Leveson.
Yes, it is, and in fact...
Or the
last
two
sentence,
judges.
The last sentence can't be, because it talks about consultation. Lord Justice Leveson...
in fact, the paragraph, we can see paragraph 239 of Leveson is actually at page 427.
Thank you.
So we can test that.
Fine. Well, we can do this. We can do this later.
Deal with that.
Don't
But
worry
that's
now.
but that's so we say that it's
It stops with nor the public. Yep.
Yes.
Thank you.
it's good. I'm grateful.
Yep.
Relevant that in the context of actions for defamation, the courts appear to have recognised that the making of allegations can damage someone's reputation, even if they are mere allegations. I'm thinking of Lewis and the Daily Telegraph,
Yes.
a report that somebody was being investigated by the fraud squad was held to be defamatory.
Yes.
And they specifically rejected the suggestion that that was simply a report about what was being investigated and not a report that there was any truth in it.
Yes. Well, Lewis and Daily Telegraph is an interesting example because that was the famous case where what was published was the mere fact of a police investigation. I think there's a passage, if memory serves, from I think Lord Devlin, where he says, well, the member of the public who reads it will say, well, just hang on, let's be fair-minded here. It's just a police investigation, there may be nothing in it, and so forth. Now, that is a rather lofty, we would say, ivory tower analysis, perhaps of a bygone age, which doesn't always reflect the way in which people read the media and the conclusions. Not saying all the public, clearly the Council of Perfection, reasonable members of the public who are reasonably well informed, will understand. There's no, the suspicion is just that it may prove to be ill-founded, but sadly there will always be significant sections of the public that will go down the no smoke without fire route and may be more inclined to feel the taint of guilt in cases particularly involving emotive subjects such as child sex abuse.
Well, the important point is that the report was defamatory. The
Yes.
important point is that to report that somebody was being investigated was held to be, if I remember correctly, was held to be defamatory.
Yes, I think that's from memory. That's correct. But the
I might say that the Section 4.2 order itself is also premised on the risk of prejudice to a fair trial by reason of the fact that somebody has been arrested for an offence of this nature being publicised.
to come back to my Lord Sumption's question, of course, we know from the Chase case that there are three tiers, or generally held to be three tiers of defamation. One is the suggestion of guilt, one is a reasonable suspicion of guilt, and one is that questions need answering. Now, a lot of people have called into question whether there's any real difference between the second and the third of the Chase categories, but I suppose one could say that the fact of a police investigation would be defamatory under the third, that it's effectively, in some way, a claimant, or in this case the appellant, has conducted himself in a way such as to arouse police suspicions and call for him to give answers. So there is the reputational damage. I wouldn't want it to be thought, though, having regard to the evidence given in the case that was summarised, which is, the witness statements are here, I'm not going to go to them, but you'll have seen it's not just a question of reputational damage and the distress, but also you'll have seen references to the children of the family and their particular vulnerability. So it's often not just reputational harm that's caused. The phrase irremediable harm includes, in the most extreme cases, going into hiding, people being attacked and vilified by vigilante-style, self-righteous members of the public, and so forth. And indeed, if you've had a chance to look at particularly the first of the appellant's witness statements, you can see that it already appears to have been exposed to some element of limited, of harassment of that kind. Again, I'm not going to get into the specifics. But yes, your Lordship is right. I mean, that is part of that. Even the mere taint from an investigation suggests that there has been some conduct or some circumstances on the part of an individual such as to bring the police in his direction and to result in him, in a case such as this one, in having him arrested. So I hope I've dealt with what originally started as, I hope, my lady question. If it assists, and if I've laid the groundwork for it, what I was proposing to do is to do a fairly, I hope gentle, because these are cases your Lordships either have read or will be reading, but a gentle trot of the highlights of what we say are some of the judicial pronouncements that feed into the recalibration of those 5 areas that we've identified as being ripe for reappraisal in looking again at the open justice principle. I'm not going to take them in any particular order. I will start, if I may, with the Axel Springer case. And again, I'm hoping my references for these are going to be accurate. I'm working from the paper bundle. It starts at page 727, I'm grateful.
Which flag?
727.
Flag 14.
In the paper bundles,
Yep.
it's authorities 1 tab 14.
Yep.
And I can just summarise this. Mr. Springer was Axel Springer were the publishers, but the individual concerned was an actor in a TV series who had been arrested at the famous Munich Beer Festival for drug-related offences. And this had ended up being published in 2 articles in the well-known tabloid magazine in Germany, Bild. Perhaps I'll just touch on holding 13 on page 730. There was a violation of Article 10. There were some quite draconian steps taken on the publication by the German court, which I'm not going to delve into. Holding 26, see at page 734, the articles in question concern the arrest and conviction of X, that is, public judicial facts which might be considered to be of general interest. The public had an interest in being...
Sorry, I beg your pardon, holding what?
It's holding 26, H26.
734.
It's on page 734.
Yes. Holding 13, effectively.
Yes.
Yeah.
Well, it's actually paragraph 13, it's paragraph H26, it's
Thank
holding
you.
13, yes. The articles in question concern the arrest and conviction of X. That's public judicial facts, which might be considered to be of general interest. The public had an interest in being informed and in being able to inform themselves about criminal proceedings. That interest might vary in degree, however, during the course of the proceedings according to a number of different factors, such as the degree to which the person concerned was known, the circumstances of the case, and any further developments arising during the proceedings. And we've highlighted that particular finding. Of course, the importance in being known in the public interest varies according to the circumstances of the case. And we would draw a distinction in this case, for instance, between knowing the details of a very important criminal trial at the Old Bailey, the witnesses, the accusations made against the various accused, and contrast that, what we would say would on any view be the rather more limited interest in a Section 4.2 argument concerning a party who was neither a witness nor an accused, who was just brought into the proceedings by a side wind. So that's an important point of principle. Holding 15 a bit further down, as regards the subject of the articles, the court broadly agreed with the domestic court's assessment of the applicant's interest in publishing the articles in question. It had been due solely to the fact that it was X who had committed the relevant offence. Had the offence in question been committed by a person unknown to the public, it would probably never have been reported. And then this, however, X was arrested in public. This fact was a matter of important public interest in accordance with the Court of Appeal's view, even if that interest did not extend to the offence itself, which had been committed out of public view. And again, that's perhaps an important feature to contrast with the present case, and why we say a case-by-case analysis may be is obviously the best way forward. There may be extreme cases where somebody is apprehended and arrested after a shootout or whatever it may be in very public circumstances. Different conditions would obtain. This was a case involving a very minor drug possession charge. In fact, I think he was arrested on coming out of the toilet. So we say that's very different to taking part in an exploitative paedophile ring. And of course, it was an arrest and conviction. The second article was relating to the conviction. These were described as public judicial facts. Compare and contrast, we say, to a case such as the present one, where there is simply an arrest, which then leads to a de-arrest and doesn't lead to any criminal proceedings. Perhaps if I can just go to paragraph 80, which is at page 756.
Yes, 80 up.
Page 756.
Yeah.
I'm grateful. Again, the court in paragraph 79 talks about the essential role played by the press. Duty extends, it says in 80, to the reporting and commenting on court proceedings, which, provided they don't overstep the bounds set out above, contribute to their publicity and are thus consonant with the requirements under Article 6.1 of the Convention that hearings be public. It is inconceivable that there can be no prior or contemporaneous discussion of the matters of trial, be it specialised journals or the general press at large. But then, if one goes to 96, we come to the point I highlighted in the opening, and also an observation on the presumption of innocence. The court notes that the articles in question concern the arrest and conviction of the actor X. That is, public judicial facts may be considered to present a degree of general interest. The public do, in principle, have an interest in being informed and in being able to inform themselves about criminal proceedings, while strictly observing the presumption of innocence. Then, after the citations, that interest will vary in degree, however, as it may evolve during the course of the proceedings, from the time of the arrest, according to a number of different factors, such as the degree to which the person concerned is known, the circumstances of the case, and any further developments arising during the proceedings. We pray that in aid. We say it's important here because the degree of interest, we say, is significantly diminished when all one is talking about is not one of the protagonists, witnesses, or accused in a very important criminal prosecution over a paedophile ring, when one is simply dealing with a Section 4.2 application made by somebody who's brought in, as I've said before, by a side wind. And I think that's probably all I need observe, other than you'll have seen in 100. An observation was made that X was arrested in public. That's at page 761, paragraph 100. In a tent at the beer festival in Munich, in the Court of Appeal's opinion, that fact was a matter of important public interest in the case, even if that interest did not extend to the description and characterisation of the offence. And perhaps finally, in 108, it's just observed in the last sentence the government didn't show that the publication of the articles had resulted in any serious consequences for X, as you'd expect when it was involving a fairly trivial, if to use the vernacular, drugs bust for possession of drugs at a beer festival. But we say there are two important aspects highlighted there. One is the invocation of the importance of the presumption of innocence in paragraph 96, and the need to have in mind that the fact that the public interest in a case, in a criminal case, or any case for that matter, varies according to the circumstances of the case, perhaps the stage at which the case has reached, or the particular nature of the issue involved.
So how do you observe the presumption of innocence in relation to a person who's actually charged? He's presumed innocent until proved guilty. Throughout the trial, he's assumed to be innocent. But you can publish all that.
Well, I think when he's charged, the trouble is once he's charged, he's going to be brought before a criminal court. I don't think we'd be here if there'd been a charge brought.
Well, why not? I mean, if there's to be a presumption of innocence.
Yes, I'm not seeking to argue if there should be a blanket presumption of innocence that applies.
No, but why not?
Well, that would be for Parliament to reintroduce that which was abolished in 1988, which is a general anonymity for suspects in these sorts of cases.
I mean, you might say that the fact that somebody has been charged and brought before a court was a public judicial fact, to quote paragraph 96 of the Springer case, whereas the fact that somebody has been incidentally mentioned in the course of the trial who is not the subject of any public proceedings, whatever else one might say about it, is not a public judicial fact.
No, I think that's an alternative way to look at it. And we say that it's not the public judicial facts, where, as your Lordship says, arrest and conviction. Here, we're...
Well, arrest, charge
and conviction.
And the opening of the trial against him.
Yes.
Arrest and charge, but not conviction.
I beg your pardon?
Arrest and charge,
Yes.
but not conviction.
Well, I think charged, is probably where the line would be drawn, because charge, that's the trigger. We know for Contempt of Court Act purposes, charging triggers the active period. So as a matter of public policy and statutory policy, it's clear that being charged...
Arrest triggers
arrest. I'm grateful to it's arrest that triggers the actual contempt risk, hence the making of the Section 4.2 orders in the present case, where, as your Lordships have already seen in my summary, the Section 4.2 orders were kept in place by Judge Rook unless and until a decision was made about whether he was going to be charged or not.
I mean, the reason why there is a degree of general interest in public judicial facts are that the formal acts of the state against an individual are, in a sense, done on behalf of us all. They are public legal acts, and the public can be assumed to have a legitimate concern in any public act of the state. Whether the same considerations can apply to something which is said in the course of a witness's evidence in relation to somebody who is not before the court is the real question, or one of the real questions, isn't it?
Yes. Well, I think a witness then runs into the more difficult problems that the interests of the public may be more acute. It's the Came Toddler. I mean, there's always a danger for a witness in a criminal trial. But in order to make sense of the public's understanding of the evidence in the case, it doesn't make any sense unless the witness is identified sufficiently.
Well, the statement made in the course of evidence may be integral to the case against the persons who are being tried. That may be in a different category. But the incidental character of disclosure of PNM's involvement in this case may take it outside the category of cases which is virtually by definition a matter of legitimate public interest.
Yes.
Of course, it's perfectly possible that it may be a matter of legitimate public interest for another reason, but there is a particular category of state action which is virtually automatically a matter of public interest.
Yes. And we say, I respectfully adopt that analysis, and it dovetails, I respectfully suggest, with the focus on whether the particular information contributes to the public debate in relation to the being included in the court report. It's an important...
But is arrest, what is the status of arrest in this debate?
Well, the other side have, my learned friends, I think, agree that an arrest is private, is a private matter, and I'll come at the end of my submissions just to remind your lordships of what's been said in recent times by ACPO, the police guidance, that the police themselves now take the view that arrest is not generally to be communicated to the public. So it's in essence a private act for which there is no general justification to release to the public. I'll come to those in due course. But in my 5 categories, that is the 5th one, the growing acceptance that those arrested or merely suspected of crime shouldn't generally have their identities released to the public as a matter of policy. It's in the essence of a private act, unless or until, at the earliest, the individual in question is charged and triggers the operation of the criminal justice system against him. But that's all I think I need to say about Axel Springer.
Yep.
I will then move on to deal very quickly, just so we have them in mind, for all the principles that we've brought in. The next one is a British or an English authority, which is at page 666, which is the case of C against the Metropolitan Police Commissioner.
So what flag?
That's volume 1.
I got it, yes, okay.
That's
Right. Flag 11.
tab 11.
Yep.
I'll take this fairly briskly. This was the case involving custody photographs of individuals variously accused of actual bodily harm, and the one of rape. And one of the other, so far as the rape allegations, the basic details were to be logged on the police national computer. Now, the divisional court allowed the claims by the claimants to expunge the photographs, and it's really only paragraph 54(1)
Right.
that I wish to rely on. And your lordships,
Right. That's page 691.
page 691,
Yep.
and this Lord Justice Richard said, I can accept a number of the submissions made by Mr. Johnson that the MOPI code of practice and the MOPI guidance provide a much more structured system than was under consideration in S versus UK, that they draw some distinction between different categories of offences, though the categorisations are very broad, as illustrated by the inclusion of C in Group 2, that it's permissible in principle and can indeed assist consistency and predictability to have bright line rules in this area. Nevertheless, I consider the MOPI Code of Practice and Guidance suffer from deficiencies of much the same kind as led to the adverse findings under Article 8.2 in S versus UK. And that these deficiencies are significant in relation to the retention of photographs as in relation to the detention of fingerprints and DNA. In particular, 1, no adequate distinction is drawn between the convicted and those who are either not charged, the position of the 2 claimants, or are charged but acquitted. There's nothing to meet the concern expressed by the Strasbourg Court about the risk of stigmatisation of those entitled to the presumption of innocence or the perception that they are not being treated as innocent. The reasons given by Commander Gibson in support of the individual's decisions to continue retention of the claimant's photographs underline that concern, notwithstanding that no charges were brought, let alone proved, against either claimant. The reasons rely inter alia on the fact that the allegation against each claimant remains recorded as a substantive crime. The claimant was in each case the only suspect. So again, we have an important observation in relation to both the presumption of innocence, the risk of stigmatisation, and the need to draw a proper distinction between those who are either not charged or are charged but acquitted and the guilty. Those categories are perhaps worth bearing in mind the sort of taxonomy my Lord Sumption mentioned in relation to public judicial acts and where the action of the state can truly be said to be triggered. I think I can leave that and then move on to some of the Canadian authority, which we valiantly but were unsuccessful in trying to interest the Court of Appeal in below. Again, I'll take these as briskly as I can. They're all to be found in the 2nd volume. I'll start with, and I'll paraphrase the facts so as not to take time. So I'll start with a case called BG. I'm so sorry, with a case called Briggs. That is to be found at tab 28?
28.
20, tab 28, page 1062, if it's not.
Thank you. Yeah.
Now, this was, I'll paraphrase. This was a case where the judge exercised the discretion to order DNA samples to be taken from a person charged with an offence. Now, the person B pleaded guilty to various offences arising from the armed robbery of a Toronto massage parlour, and the Crown successfully applied for a sample to be submitted to the National Data Bank. B argued that the judge couldn't make the order unless he was satisfied that the accused DNA profile would be of future evidentiary use. And it's really just some passages at 1087 to 8, paragraphs 33 to 34 of the judgment concerned. Starting at paragraph 33, the second exception to the reasonable and probable ground standard mentioned by Mr. Justice Dixon and Hunter is when an individual's bodily integrity is affected. The extent to which state intrusion with bodily integrity will be tolerated under the Charter is linked to the reasonable expectation of privacy that an individual has. There is a significant difference in the reasonable expectation of privacy, and hence the protection from interference with bodily integrity afforded to a person who is a suspect but has not been charged, a person who has been arrested and charged, a person who has been convicted, and a person who is subject to a custodial sentence, and then see various cases. In Stillman, the court held that the taking of DNA samples was state interference with the accused's bodily integrity, a breach of his privacy and an affront to human dignity. At the time that the samples of DNA were obtained, Stillman had not been convicted of a crime, and it is in that context that the court's comments must be considered. The court held that a higher justification for state interference was necessary than the common law power of search incident to arrest, and mentioned the new legislative provisions respecting DNA search warrants. A person who has been convicted of a designated offence, unlike an accused person, no longer has the benefit of the presumption of innocence. Persons convicted of serious crimes may be subject to sentences of incarceration, prison, or in jail. Such persons are subjected to strip searches and so forth. 34. Human dignity is closely aligned with an individual's freedom of choice. A person convicted of a crime has a lesser expectation of privacy, not because that person's worth as a human being is less, but because the person's right to make choices about his or her life is curtailed. That's an interesting analysis in the context of our own recent history in this country, with DNA samples and so on. But it does again illustrate the importance of the position of somebody who's simply been arrested and not been charged. And again, one has that drawing of distinctions between, at the very lowest level of the order, people who've simply been arrested and not charged. But moving quickly on, there's the case of Ebka. That's at tab 32. Again, I'll paraphrase the facts briefly. Mr. Ebka was a terrorist suspect.
Sorry, page reference.
I beg your pardon, it's page 1147 in the bundle.
Unfortunately, you have to do both.
Yes, I apologise, it's lack of habit. And tab 32 in bundle 2, for those wedded to the analogue form of looking at authorities. As I was just saying, Mr. Ebka was a terrorist suspect wanted by Germany for membership of prescribed terror organisation. I think it was the Revolutionary Cells, an offshoot of the Baader-Meinhof gang, and for explosive offences. And he sought a publication and broadcasting ban on the evidence and submissions at an upcoming extradition hearing. He was then charged separately with immigration offences under Canadian law. Now, his concern was not imperiling his right to a fair trial in Germany, but that before a local jury in the Northwest Territories on the immigration charges, and the case being that allegations of terrorist activity were inflammatory and would suggest that his motive in going to Canada was to avoid detection or arrest in Germany. Now again, I'll take this at a brisk canter. Paragraph 23, 153, this is reference to the Canadian experience of the open justice principle. Concomitant with freedom of the press is the concept of open justice. In Southern, it was held that even though free access is not specifically enumerated under the heading of a fundamental freedom, given the history of access to the courts, it is an implicit and integral part of the protection given to freedom of the press. In Edmonton Journal and Alberta, the court identified the aims underlying our commitment to the principle of open justice. The first is tied to the belief that open proceedings foster the search for truth in civil and criminal cases. The second is the importance of public scrutiny and at times public criticism of the courts. Accordingly, since freedom of the press is of fundamental significance to a democratic society, the press must be free to comment upon court proceedings to ensure the courts are, in fact, seen by all to operate openly in the penetrating light of public scrutiny. The concept is tied to the fair trial guarantee and so forth. And then this in paragraph 24 says, so far, so concomitant. To this constellation of rights, we must add a third one. That is the right to privacy. In this case, we must keep in mind that Ebker is presumed innocent of the Immigration Act charges until proven guilty. So were the three other individuals charged under that act. We must also keep in mind that the extradition charges are just that, charges, and he is presumed innocent of those even if he's extradited. I note that Article 6 of the European Convention, to which Germany is a signatory, guarantees a presumption of innocence in terms very similar to Section 11D of our Charter. Thus, an accused person, even if he or she can be labelled only as presumed innocent, has an interest in maintaining his or her privacy. This was a point made in the well-known case of McIntyre, where Mr. Justice Dixon, on behalf of the majority, wrote in holding that public access to search warrants prior to their execution was properly prohibited, but not thereafter, that in deciding whether or not to grant press access, the court must consider several broad policies, including the privacy interests of the individual involved, protection of the administration of justice, and the strong public policy in favour of openness in respect of judicial acts. Similar sentiments were expressed by both the majority and the minority in the subsequent case of Vickery. Pausing there, and I'm not going to preempt my reply to my learned friend's submissions, one reason why the Australian experience may be of little value to us is that Australia does not yet recognise a right of privacy, unlike Canada. So there we have invocation of the presumption of innocence and the right to privacy. Interestingly, in paragraph 44, just for completeness, there's a reference to, that's on page 1158. The salutary benefits of a publication ban are that it would A, protect trial fairness for the Immigration Act trial, B, preserve Ebker's privacy from the dissemination of what would be merely allegations, and C, avoid delays in the immigration trials and so on. So again, it's an analysis we say is apposite in the present case. In the presumption of innocence, we're dealing with what are at best allegations, and in the case of somebody who's simply been arrested but not charged, at best inchoate allegations. And then finally, paragraph 47, you'll see that there was a ban was imposed on the reporting of the evidence and the submissions in the extradition, but not the charges or the nature of the outcome. There then comes the case of Henry, which I did get a chance to refer to below, and to which Lady Justice Sharp actually expressly refers, although has not been very helpful, below. That's at tab 30. It starts at page 1108.
Thank you. Yep.
Again, if I may, I'll paraphrase the facts. The applicant X was a person on whom suspicion had fallen after H, Henry, had applied to reopen appeals on 1983 sex offences, conviction for sex offences in 1983. Supposing that X was the person who was now in the frame. There was fresh evidence of the DNA profiles of other offences committed after Henry's arrest involving a similar modus that matched X's. That's to say the DNA profiles matched X's. Three complainants had photo-identified X. I put in parentheses, compare and contrast here, where there was no, as we know from Mr. Justice Tugendhat's judgment, there was no ever any identification of the appellant in the present case. X was arrested, charged, and then pleaded guilty, and he spent 40 months in jail and was now on parole by the time of this hearing in British Columbia. Now, the DNA was not available for the remaining assaults that had been committed while Henry had been wrongly in prison. And the Crown sought a ban on the publication of X's identity. Perhaps not surprisingly, H opposed that. Can I just take you to, it's a very short judgment, paragraph 60. I think I may have given a wrong tab number. It's tab 29, I beg your pardon.
Yes.
Paragraph, I'm now on page 1117 of the electronic bundle, paragraph 16. Counsel for Mr. Henry contends in the case at the bar that Mr. X has, quote, little or no privacy interest with respect to the matters connected to Mr. Henry's appeal, and certainly has no privacy interest in connection with the 3 assaults for which he, Mr. X, was convicted and is still serving a sentence. Mr. Layton emphasises that counsel for Mr. X has not pointed to any case, this is a passage my friend relies on, any case involving a third-party suspect where a ban has been ordered based on privacy concerns, and emphasises that in several cases the identity of a third-party suspect has been publicised in the course of post-conviction proceedings. In R versus Milgard, for example, the name of Larry Fisher was publicly known as the real suspect, and he was subsequently tried and convicted, see Baltovich and other cases. The latter 2 cases involving evidence pointing at Paul Bernardo, who was, of course, already in prison and publicly notorious. Compare and contrast with the present case. 17. In this case, Mr. X is on parole and living in a halfway facility. He has not been charged, again, compare and contrast, and unless until he is convicted, he is presumed to be innocent of the unsolved offences which were the subject of the Smallman investigation. The publication of his name is not necessary in any way to Mr. Henry's appeal. The public interest in the openness of trials and the administration of justice is not, in my view, diminished by the withholding of his name. And just to paraphrase Paul's there, in the same way in the present case, the publication of the section, an account of the Section 4.2 proceedings would not be diminished in any way in terms of the public's understanding by withholding PNM's name. Reading on, all proceedings have been and will continue to be carried out in the open. On the other hand, the reporting of Mr. X's personal circumstances, combined with the inflammatory demands by the media that his parole be revoked and the statements that he is a, quote, prime suspect and a, quote, dangerous sexual predator being allowed to live anonymously among us, mean that Mr. X's privacy and even security interests will be at risk if his name is published, more so than in the usual case of persons suspected but uncharged. If our society takes seriously the proposition that a person in Mr. X's position is presumed innocent until proven guilty, it seems to me that the deleterious effects, both on his privacy interests and on the administration of justice, of the publication of his name do outweigh the public interest in knowing of that fact. And before I leave the case, it goes without saying that the potential deleterious effects of grave sexual offences against children are of a very high order on any view. Now, can I then turn to the 2 BG cases, which I'll take. The first one in 2002 is at tab 20, page 891. I'll just set the scene for what these cases was about. In fact, this concerned civil proceedings. It was a negligence action for damages for historic physical and sexual assaults at a state facility for boys who'd been involved in juvenile delinquency proceedings or on probation. Sadly, familiar factual scenario, it must be said. Now, the Crown was the defendant, and it sought to the civil proceedings, and it sought a publication ban on the names and identifying of the former personnel at that facility. And just so you can see the summary of the conclusion, paragraph 7 on page 895. Question, should a partial publication ban be ordered to protect the identities of the following categories of individuals? Firstly, the former BLS was the name of the home, personnel accused of perpetrating physical and or sexual assault against the plaintiff. A, this issue necessitates a consideration of the effect, if any, that the fact many of the alleged abusers are deceased has on the decision to grant a partial publication ban. 2, the former BLS personnel accused of learning of the occurrences of abuse and failing to respond to them. And 3, witnesses who will testify for the Crown who are not accused of any wrongdoing. I've concluded that the answer to category 1 is yes. The answers to categories 2 and 3 are no. The following are my reasons. So the ban was upheld in relation to the alleged perpetrators, but the public interest in maintaining anonymity was felt not to extend to the guilty people who did nothing about the accusations or simple witnesses who appeared for the Crown. I hope I can take this as a pretty brisk whistle-stop tour. Paragraph 13, to save me going to McIntyre, you'll see a citation from McIntyre, looking at the Canadian experience. While free access, this is page 896, while free access has been considered essential for maintaining public confidence in the judicial system, there are recognised exceptions to the open court principle. In McIntyre, Mr. Justice Dixon, as he then was, said, in my view, curtailment of public accessibility can only be justified where there is present the need to protect social values of superordinate importance. One of these is the protection of the innocent. Protection of the innocent from unnecessary harm is a valid and important policy consideration. In my view, that consideration overrides the public access interests in those cases where a search is made and nothing is found. The public right to know must yield to the protection of the innocent. And there are analogies, we say, to be drawn there. If an arrest is made, nothing comes of it and the individual has to be de-arrested. It's the equivalent, we say, of a search being made and nothing being found. And we say that the presumption of innocence should be treated as a value of superordinate importance, certainly more so than it's been given in our courts in recent times. Paragraph 38, which is at page 896, I think I can move on from that to, sorry, it's page 901.
Thank you. Yep.
The authorities established that protection of the innocent is a social value of superordinate importance that may justify overriding the general principle of openness. It is not just because untested allegations are being made against someone that this exception will apply. We do not protect the identity of all defendants in civil actions. It's necessary to consider the nature of the allegations made against an individual. The court protects those who may suffer irreparable harm to their reputation. And again, that's a point picked up by my Lord Sumption. It's not just, we would say, reputation, but the other consequences that flow in terms of irremediable harm. Paragraphs, reading on the pleading set out a number of allegations against the alleged abusers. I'm mindful of the fact there have not been any criminal charges or convictions against any of them, and the allegations in this civil proceeding have not been tested in court. They are innocent, as that word is used in a narrow sense in civil proceedings to describe persons against whom unsubstantiated allegations are made in pleadings. 41, and this we say is not unimportant. The names of these individuals appear in the statement of claim along with scurrilous allegations of the most serious sort. They are alleged to have committed heinous acts of physical and sexual assault against the children whom they were hired to care for. Essentially, these individuals are accused of being paedophiles. They have been put in the category of persons most condemned and reviled by society, and we adopt that characterization of people in that position. An accusation of paedophilia is indeed to be placed among the most condemned and reviled by society. Reading on, in deciding whether these allegations are of the sort to cause irreparable harm, the specific facts of this case must be taken into account. The Crown has introduced evidence that the publication of names in relation to this case has already affected greatly the individuals involved. While I have not considered general evidence relating to the stressful nature of these proceedings, I'm concerned about the impact that these very serious allegations have on the reputations of the individuals living in the relatively small community of Nanaimo. Crown introduced evidence that when the names of some of the individuals accused of the scurrilous conduct became public, the individuals and their families were immediately condemned and shunned by their community. Pausing there, there's the question put to me by Lord Wilson in terms of availability of evidence in relation to public attitudes. There is some evidence here in the first statement of the appellant, but I'll come back to that in my final submissions. While I'm not considering the impact of these allegations on family members, I can find that these sorts of actions evidence the severe impact that these allegations can bear on a person's reputation. Evidence that neighbours will no longer even associate with family members of the alleged abusers indicates how a person's reputation can be destroyed once his or her name is published in association with these allegations. Members of the community are not waiting to find out if the allegations against the alleged abusers are proven. Rather, they are judging them as guilty before the trial has taken place. Because there is no opportunity for anonymity in a small town, the individuals accused of abuse may have no way of preventing their reputation from being besmirched and ultimately destroyed in the eyes of their community. It's imperative to prevent that harm to their reputations unless and until these allegations are proven. Yeah. While I've found that the value of protect the innocent applies to the alleged abusers in this case, the fact that many of them are deceased must also be taken into consideration, and so forth. So, pausing there, we say that's a much more realistic analysis, we say, of the dangers than simply to have the traditional judicial invocation of the principle that members of the public are fair-minded and can distinguish between a mere suspicion and guilt. Sadly, where allegations of this kind are concerned, they are more prone to draw the taint of guilt.
Do we gather from the fact that it was the Crown that was introducing this evidence, that the Crown was supporting the ban?
Yes, the Crown was asking for the ban. And the Crown was I think, sued as from memory, as the owner of the home. And it was seeking the blanket ban that we saw in paragraph 7 across the board. But the court was having none of it. It said, well, we're certainly not going to protect witnesses, and we're certainly not going to protect those members of the staff who are in the frame simply because they were told about the abuse and did nothing about it. The people who were protected were those who were put at risk of irremediable harm by being publicly stigmatised and pilloried as suspect paedophiles for the reasons set out in the judgment. I think quickly just take on few final passages. Paragraph 52 on page 904. This is back to the presumption of innocence. Paragraph 52, the protection of the innocent exception addresses the concern that if a defendant should not be denied the right to be considered amongst the innocent until allegations against him or her are proven. Allegations are found either to be either proved or disproved at the end of a trial. Further, the alleged perpetrators of abuse are not named as defendants in this case. They have no way of controlling the proceedings. For example, they cannot use interim applications as a filtering process. Pausing there, in the present case, of course, the irony is that PNM is almost in a worse position than an actual accused, who at least would have lawyers acting for him and all the rest of it. Here he's in the worst imaginable position because no charges have actually been formulated against him. The suspicion against him is purely inchoate, simply by virtue of the fact of being arrested. Reading on, 53, I have no difficulty in concluding that if the names of the individuals accused of being paedophiles are published, their reputations will suffer untold harm before any finding of misconduct has been made against them in a court of law. Though many of the individuals are now deceased, their reputation will also have suffered irreparable damage without them having had any chance to refute the allegations or defend themselves. In balancing the public interest in open proceedings against the private interests of the alleged perpetrators of abuse in this case, it's imperative to prevent that damage from occurring unless and until the allegations are proven. The potential harm to the private interests of those individuals, if the protection were wrongly refused, outweighs the harm to the public interest if it were wrongly granted. Therefore, until a finding of misconduct has been made against these individuals in order protecting their identities is necessary in order to provide some measure of protection against the still unproven allegations made by the plaintiffs. If the allegations against them are proven, a finding will be entered in that regard, and the public will have access to the names of the individuals who perpetrated the crimes. And then I think, I won't read them out, but at 55 through to 60, you'll have a consideration of the position in relation to the other individuals. Just perhaps pausing to look at paragraph 56 on page 905, I find that the situation with regard to these individuals is quite different from those of the alleged perpetrators of the abuse. There was then a second BG case. After the claimant failed at trial, the judge lifted an order banning publication of the plaintiff complainants and the various individuals who were described as similar fact evidence witnesses, that's to say other boys who claimed to have witnessed abuse. I won't dwell on it, but it was a damning finding, and the boys were disbelieved and their evidence found unsatisfactory. The point of interest in this case from our point of view really is paragraphs 20. Perhaps I'll start from 24 because it contains a useful summary of the Canadian Mentuk-Dagenet test.
It's page 919.
Page 919, yes.
Thank you.
R versus Mentuk. The Supreme Court reformulated the test articulated in Dagenet so that the focus of analysis is a weighing of the broad competing interests in a publication ban, including those that are specific to the parties and to the public more generally. Yakabuchi J for the court stated at 32, a publication ban should only be ordered when A, such an order is necessary in order to prevent a serious risk to the proper administration of justice, because reasonably alternative measures will not prevent the risk, and B, the salutary effects of the publication ban outweigh the deleterious effects on the rights and interests of the parties and the public, including the effects on the right to free expression, the rights of the accused to a fair and public trial, and the efficacy of the administration of justice. 25. Although Dagenet and Mentok both deal with principles that govern the making of discretionary publication bans in the specific context of criminal proceedings, I consider the general approach and some of the factors mentioned in those cases to be relevant to civil actions involving claims of historical sexual abuse. The particular circumstances of the present case, the judge should have considered the effects that ending the ban would have on the plaintiffs, their witnesses and other former inmates of Brennan Lake School. Perhaps of equal importance, the judge should have also considered the chilling effect the prospect of termination might have had on those pursuing similar claims for historical sexual abuse, and hence the administration of justice. The judge should also have considered that courts have frequently recognised that replacing the names of certain parties with initials relates only to a sliver of information and minimally impairs the openness of judicial proceedings. And I won't list all that citation. But one might feel, and we would argue in this case, this is a particular case where, because the individual is only involved in the big criminal trial by a side wind, the identity of PNM, we would say, is indeed a sliver of information as a bit player who only got brought into the proceedings by virtue of a collateral Section 4.2 hearing at the main event of the criminal trial. And just for completeness, it's interesting to see at paragraph 32 that the judge, the ban was temporary and it was lifted just at the top of page 90. I won't read out the judge's reasons for lifting the ban, but you'll see over the page at 94, the presumption that the school staff members were innocent of any wrongdoing remains in place. None of the plaintiff's allegations against them were proven. So the position of the various individuals, staff members, had been vindicated as a result of the judgment. McIntyre, I don't think I'm going to go to, because we've looked at the citation already. I shall go straight to a case, I think the last Canadian case, you may be relieved to hear, is a case called In the Matter of an application, a very lengthy title, Unnamed Person, I've called it.
Where do we find it?
You'll find that at tab 26, page 1026.
Thank you.
Again, I'll paraphrase the facts. The unnamed person was a doctor, and back in 1990, a former woman patient of his from the 1980s complained to the police of sex offences having been committed by him against her on 3 occasions. A policeman at the time investigated the offences and no charges were laid after the various witnesses that she'd put up denied all the corroborative details that she'd relied on in every instance. Interestingly, the unnamed person, the doctor, successfully submitted to a lie detector test. Now, in a twist in 2003, the doctor became the victim of extortion by a completely different female. A PC Lynch of the Royal Canadian Mounted Police reopened the earlier complaint from 1990 and forcefully told the doctor that he'd failed the earlier test, when in fact he'd passed it. So the doctor agreed to another test, and PC Lynch again told the doctor that he'd failed. Now, the doctor, suspecting that he was about to be charged, applied for a publication ban, and a few days after he made the application, all of the various informations were ultimately withdrawn or stayed by the Crown. So the hair having been set running and the information having been laid in the event the prosecutor withdrew or stayed all the charges. The ban was resisted by the Canadian Broadcasting Corporation, and I would just ask you to look at paragraph 18 on page 1031. The CBC strongly urged that no ban is warranted. It relied heavily on freedom of expression and the public's right to know in support of this contention. The applicant warned of the potential floodgate argument if one such ban is granted, as it is without precedent. The CBC further submitted that the only basis for the request is the privacy interests of the unnamed person, the doctor, and that is not sufficient reason to override the public's right to a completely open justice system and the constitutionally guaranteed freedom of the media to report on matters coming before the courts. The CBC stated further that there is insufficient evidence before the court to determine what, if any, harm might befall the reputation of the unnamed person if his name were to be published. It said further that any alleged weakness in the case against the unnamed person is irrelevant. Counsel submitted that Parliament has chosen to grant extremely limited rights respecting publication bans in the Criminal Code, and related statutes, and this court should not presume to extend the right, especially when it tramples on the fundamental rights of the freedom of expression and an open and transparent justice system. So a lot of echoes of the sort of submissions one has in this case and these sorts of cases. And I'll turn then to look at the court's analysis of necessity, because it has particular resonance in relation to the issue of stigma. Paragraph 29 on page 1035. There is no effective means of protecting the privacy interests of the unnamed person in this case, short of banning the publication of his name or information by which he might be identified. The stigma associated with a charge of sexual assault or related charges is obvious, in parentheses, a fortiori, in relation to sexual offences concerning children, and especially in the case of a professional in a sensitive career such as medicine. Counsel for the CBC suggested that the potential financial implications for the unnamed person cannot be presumed and must be grounded in the evidence. While this is so, it would be difficult, if not impossible, to produce evidence in advance of the financial damage which might affect the unnamed person if his name were to be published in connection with these charges. A similar charge against another doctor in the same hospital resulted in the suspension of that doctor. It's reasonable to infer, therefore, that the unnamed person would receive no more favourable treatment than that of his colleague. It's also reasonable to infer that at least some patients, particularly women, would refuse to see the unnamed person in the face of charges by some of his patients that he sexually abused them during medical examinations. Pausing there, another more realistic evaluation of the fact that people tend to, however unreasonably, make the taint of guilt from mere suspicion. The harm to the unnamed person's family of allegations of sexual assault are also obvious and require no real proof. We endorse that analysis. In a small town such as the one in which the unnamed person practiced, the stigma attached to allegations of sexual assault against a physician would be difficult, if not impossible, to erase, even if they were later proved to be untrue. It cannot be presumed that every person who heard of the initial charges would hear of the later exoneration. And despite the constitutional right to the presumption of innocence, in my respect for you, it is human nature for some people to believe that there must be some element of truth to such allegations, or they would not have been made. The damage to one's reputation is incalculable. One cannot unscramble an egg. In my view, the flexible approach mandated by the Supreme Court of Canada in Mentuk supports a finding on the facts of this case that the loss of the unnamed person's privacy rights presents a serious risk to the proper administration of justice if the ban on publication of his name is not continued. It is not necessarily an inevitable consequence of being charged with a criminal offence that a person's name is published in the media, nor is it a core function of the criminal justice system that no exceptions to full disclosure of all details of criminal charges, those charged must be made public in order to maintain a transparent justice system. The purpose of a transparent justice system is to ensure that it's administered in a fair and impartial way, free from improper inferences, that the general public maintains faith in its decisions and makes responsible judgments based on those decisions and procedures. If the case against the person charged is as apparently weak as in this case, and is contrary to the proper administration of justice for that person and his family to be exposed to the public stigma of having his name published in the media as the person charged with a sexual offence, if it can reasonably be avoided, and we would argue as it can reasonably be avoided in this case by removing the simple sliver of information from the ostensible Section 42 court reports that these respondents claim they wish to publish. 34. I acknowledge the point raised by counsel for the CBC that most, if not all, persons charged with offences at least initially profess their innocence. The strength or weakness of a case should not be prejudged. It's for the court to decide the guilt of the person charged. It's an unfortunate byproduct of the criminal justice system that persons' names who are ultimately found to be not guilty are published in the media. The CB says that this is a regrettable price that we must all pay in order to maintain confidence in the integrity of a completely open justice system. That effectively, we say, is what is the nub of the submissions here, that PNM must be effectively sacrificed on the pyre of the open justice principle because it is, to paraphrase, freedom of expression and the reporting of the courts is a superordinate, of such superordinate importance that it must effectively trump the privacy rights and the rights to avoid stigma of individuals.
Now, as the judge emphasised there, that was a first instance decision rather than an appeal. I presume at some point you're going to take us to Mr. Justice Tugendhat's judgment and show us where he went wrong.
Yes, I will do that. I'll be coming to that probably after the adjournment, because I'm just going to finish the trotting through the authorities. And then just on 37, the last paragraphs I think we need to look at here are the question of balance. As I've already stated, there doesn't appear to be any reasonable alternative to a publication ban. Naming the respondent to respect his privacy interest, that doesn't end the inquiry. I must now weigh the salutary effects of the publication ban against the deleterious effects of freedom of expression, and there on so forth. And 39, here there is no ban on evidence, except to the extent that it would tend to identify the unnamed person. The court was not closed to the public or the media. Indeed, the media reported widely on the story, providing considerable detail on the allegations, including the name of the town where the unnamed person practiced, the fact that the doctor, and so on and so forth. 41, you'll see there another reference to the protection of the innocent as being a value of superordinate importance, justifying public curtailment of access to the courts, although, as we would say, not in every case plainly. And there's reference in 43 and 44 to the fact there'd been an earlier police investigation. And then 44, the banning of the publication of the name of the unnamed person or evidence by which he could be identified while allowing all other evidence to be published is a reasonable compromise to full disclosure in this case. The unnamed person would be at risk of suffering substantial damages, loss of professional and personal reputation if his name were to be published. It cannot be ignored that the person practiced in a small environment where anonymity is next to impossible, and so forth. 46, I think I'll end on that. On the facts of this case, the values of an open court have not been and not compromised by banning the publication of the unnamed person's name or information by which he could be identified. The media and public have had full access to the court, in parentheses, as they have here. The decisions of the court and the considerations leading to them have all been open to the media and have been reported on, in parentheses, and could be here, without naming PNM. The only information withheld from publication is the identity of the unnamed person. Counsel for CBC put considerable stock in the floodgates argument, suggesting that if the ban is continued, then all accused persons can be inspected to seek similar protection. That may be so, however, I doubt it, and in any event, every case must be decided on its own merits. The facts in this case are exceptional, and in parentheses, we say, so are the facts in this present case. I anticipate my lady, Baroness Hale's questions to me anticipated the floodgates argument being raised. There will be exceptional cases, but if there is the recalibration for which we argue, it'll become more apparent to potential applicants, potential media respondents, the sorts of cases that are likely to meet with a favourable hearing in court. But they will still be exceptional cases, and we don't argue that this is the sort of application that only ought to be made in exceptional cases, such as the ones in these cases. And now here endeth the review of Canadian authority. I will just, conscious of the time, I shall come on to S versus UK, which was the great European decision that led to the spanner in the works of our DNA procedures. That is to be found in volume 1.
As a matter of interest, I haven't gone through the list of authorities. You've cited a collection of first instance and first appellate decisions to us. The principles of the law of Canada were laid down by the Supreme Court, obviously in 3 cases, which are cited in the judgments you've given us. Do we have those 3 cases?
You have
McIntyre, Mentor, and the earlier one.
I think we have McIntyre, but not the others.
Why are you going to first instance cases rather than the principles laid down by the Supreme Court of Canada?
Because to get a flavour of how the principles, it's not so much for the findings of legal principle, but the way the principles are applied in Canada, having regard to the fact that their system, as we've seen from the Dagenet-Mentok test, is not that dissimilar from ours in that it allows for consideration of the privacy rights. And we
of course, that's why I was asking you why you didn't go to the principles.
Well, I think the principles of their statement.
No doubt your opponent could go through Canadian cases and find first instance decisions which have reached a different conclusion on the balance. He has, actually, but...
Yes, well, I'm sure one can find, can always find different cases. But these are cases that focus on the stigma questions, the sexual offences element, which we say important. And I'll come to 2 recent, one English authority in Rotherham, where we see a similar sort of approach being taken. And indeed, Mr. Justice Cobb's reaction to these points of, certainly in relation to stigma, in relation to the presumption of innocence, and in taking a more sanguine view of the public's reaction to accusations and the taint of guilt, is perhaps a more modern and realistic one than the rather more traditional view taken by Mr. Justice Tugendhat, but I'll come to the Rotherham case in due course. The only point, I'm not going to take time with S, other than, which is at tab 16 in volume 1, other than to record it, paragraph, this is the DNA case, which will be more than familiar to your lordships.
Yes.
And it's really paragraph 122 on page 827.
122.
122, yes, on page 827. Of particular concern in the present case is the risk of stigmatisation stemming from the fact that the persons in the position of the applicants who've not been convicted of any offence are entitled to the presumption of innocence, are treated in the same way as convicted persons. In this respect, the court must bear in mind that the right of every person under the Convention to be presumed innocent includes the general rule that no suspicion regarding an accused's innocence may be voiced after his acquittal. It's true that the retention of the applicant's private data cannot be equated with the voicing of suspicions. Nonetheless, their perception that they are not being treated as innocent is heightened by the fact that their data are retained indefinitely in the same way as the data of convicted persons, while the data of those who have never been suspected of an offence are required to be destroyed. So it's the risk of stigmatisation, and even the perception of stigmatisation was held by the court to be a matter which could be weighed in the pot. Now, can I come to, and it hopefully takes me to the matters concerning where we say Mr. Justice Tugendhat went wrong, so taking my prompt from my Lord Reed, can I come to the case of ERY, which is a relatively recent decision of Mr. Justice Nichol at first instance. That's at MS 553, I hope, which is also tab 6 in volume 1.
Right.
And this concerned, this is an application for an injunction. Just so you have the background, paragraph 6, the claimant's company A, was in a business relationship with another company B. 7, earlier this year, officers from a police force outside London investigation allegations of financial crime searched the premises of companies A and B. The claimant was later interviewed by police under caution. It is the information that he was interviewed under caution, and more generally that the police are investigating his suspected involvement into financial crime, which the claimant says is private and confidential information that the defendant should be restrained from publishing. So we can see there some resonance with the present case. Now, can I just draw your lordship's attention and your ladyship's attention to paragraph 52, paragraph 52.1. In the case of the managing editor of the publication in question, has said that it does not intend to publish the fact of the claimant's interview under caution. Mr. Caldecott has repeated that before the court. Furthermore, he has accepted that, as matters presently stand, publication of that fact would impinge on the claimant's reasonable expectation of privacy, and that there is not a sustainable argument as to why the defendant's Article 10 freedom of expression should prevail over the claimant's Article 8 right. He has therefore, in effect, accepted that as matters presently stand, the defendant would not have the right to publish the fact that the claimant was interviewed under caution by the police. Well, I accept that this is short of an undertaking to the court. It would be an extremely serious matter for the defendant to resile from that position without giving notice to the claimant. Associated Newspapers is not an infrequent litigant, and a recognition of the harm which would ensue to its reputation in the courts from taking such a course would, in my view, be a significant disincentive from doing so. We say that is a very different situation to the scenario faced by Mr. Justice Tugendhat, where there was no outright acceptance that there was no justification in any circumstances for publishing what we would argue is the private information of the claimant's arrest. All that was being said by the time of the hearing before the first instance judge here was that they would only publish that information in the context of the Section 4.2 proceedings. So one has to measure that undertaking with what is on offer here. You will see an interesting reference by the judge to paragraph 56, taking support, paradoxically, from what was said in this case at first instance. Paragraph 56, Mr. Sherborne points to the guidance on relationships with the media published in the Police of Policing in May 2013, and this is a passage we relied on below which I'll refer later. Yes. Police forces must balance an individual's right to respect for private and family life, the rights of publishers to freedom of expression, and the rights of defendants to a fair trial. Decisions must be made on a case-by-case basis, but save in clearly identified circumstances or where legal restrictions apply, the names or identifying details of those who are arrested or suspected of a crime should not be released by police forces to the press or the public. Such circumstances include a threat to life, the prevention of the detection of crime, or a matter of public interest and confidence. This approach aims to support consistency and avoid undesirable variance, which can confuse press and public by emphasis. The relevant police force has adopted this guidance in respect of people who have been arrested. The College of Policing guidance followed the report of the Leveson inquiry, which had said at paragraph 239, which we've already looked at. I think it would be made abundantly clear that... Yes, we read it, I'm grateful. And then we have 58. Some judicial support for this approach can be found in the decision of the Court of Appeal in PNM. In that case, the appellant had been arrested as part of a child sex abuse investigation. He was not charged with any offence, but his name was mentioned at the trial of those who were. A temporary restriction on publication was made under Section 4.2, but when that order came to an end, and he issued the present proceedings for a permanent injunction in reliance on what he said were his rights under Article 8. The claim failed because the court held that the right of the press to report what had been said in open court should prevail. And in the course of the judgment, there's a citation to Lady Justice Sharp's judgment referring to what I said, where there was the acceptance by her that the material that I cited afforded some support for the proposition that there should be a more careful consideration of such a person's right that there might have been in the past. So that was gratefully seized upon by Mr. Justice Nichol, despite the ultimate finding in the case, that the door had been open to a consideration of the rights of arrestees. And in the event, so we've got a first instance decision, again endorsing that the rights of arrestees need greater consideration in the past. And at paragraph 71, the judge found that this was not a case where the defendant's rights under Article 10 were likely to prevail over the claimant's rights under Article 8, so far as the publication of information is concerned, that he personally is being investigated by the police. Right. And well, that brings me to the last case I'm going to consider in relation to these issues, but I'm going to consider the Rotherham case. That's at 695. So we have it. Before I do, I'm going to, that's page 695, tab 12, volume 1.
You want to look at this, yes?
But before I go, I'm just going to make some observations in relation to the evidence in this case.
Right.
Now, there is no dispute as to the evidence given by the applicant the appellant in this case. Yep. Can I just give the citations? His first statement is at page 241 following. I'm not going to go there.
Thank you.
I hope for obvious reasons. That deals with the main effects on him and his family.
Which page was that?
Page 241 following.
241 following. Okay.
And his second statement is at 261 following, which is a supplemental statement which dealt with some of the more financial and business consequences.
That was
before,
MS page 338, is it?
I think it's, unless I've got it wrong, it's 26.
Well, no, the first one you said was 241. I think it's MS 338. Just make sure I've got the right page.
Yes, you're giving us the page numbers in the appendix.
I beg your pardon.
No, it doesn't matter. I just want to make sure we got it
it's
right.
MS 33, first statement 338.
Thank you.
And second statement, I can soon give you, is MS 358.
Thank you. Yep.
Can I ask you to go to Mr. Justice Tugendhat's judgment, which starts at MS 118, but I'm going straight to paragraphs 48.
Right. That's page 127. 128.
Page 12, it's MS page 129, it's paragraph 48. I'm not going to read them all out, but he sets out and describes the personal circumstances and relationships,
yep,
and so on and so forth. So we take that as read.
Right.
Paragraph 71, he records the fact that Mr. Wolanski, on behalf of the respondent, that's page 136, does not ask me to reject the evidence of the claimant, but he notes that the medical evidence relating to himself is over a year old, and that there's no evidence relating to any children from any independent or professionally qualified So the only objection taken to the evidence, not that it should be rejected, but just simply taking some points on of the sort there. And you'll see at paragraph 75 that the judge accepted the evidence of the claimant. Mr. Wolanski didn't invite me to do otherwise, insofar as he describes the impact of the events in March 2012 upon himself and his family, and his fears as to what is likely to happen if the prohibition on reporting expires. He then says this: I also accept that there will probably be some members of the public who will equate suspicion with guilt, and that there is some risk that he and other family members, including children, may be subject to very unpleasant behaviour or even harassment. That has happened in the past to people accused of child abuse, regardless of whether the accusation has any foundation in fact. Well, so far, so good, one would think. But then we have a tension with what he says in paragraph 77, where he says, I also approach the case on the footing set out in paragraph 65 above, namely that members of the public generally will understand the difference between suspicion and guilt, and will know that a person is to be presumed innocent and unless and until proved guilty. And that, to answer my Lord Reed's question, as we say, at the heart of the vice that Mr. Justice Tugendhat fell into, having accepted the evidence of the claimant, having accepted that the consequences that he feared were real ones, and that there would be sections of the public who equate suspicion with guilt, he nonetheless reverts to in paragraph 77, to the traditional analysis that because members of the public generally would understand the difference, that was enough to get the respondents home. And we say that is the vice at the heart. But the fact that sections of the public won't accept the presumption of innocence, we say, is of itself sufficient to validate a real concern about vigilante-style harassment, reprisals, and the like, particularly in the very communities affected by paedophile rings of this kind. Now,
can I ask?
Yes.
I was wondering how paragraph 77 feeds into the reasoning. Paragraph 75 goes to the harm which the appellant would suffer. So it's weighing on the Article 8 side of the balance.
Yes.
I was wondering.
It seems to be a response to the question put to me by my Lord Wilson. I mean, it was an acceptance by the judge, whether one takes it as judicial notice or coupled with the acceptance of the actual evidence given by the claimant of various incidents that had happened. He was accepting the proposition that there were likely to be members of the public who would equate suspicion with guilt, and that he found as a finding that there was some risk that the applicant and his family members, including his children, could be subject to unpleasant behaviour or even harassment. But nonetheless, that wasn't enough to stop him. This is where we say is the tension between 75 and 77. But by nonetheless approaching the case on the footing that none of that actually counts, because I have to proceed on the footing set out in paragraph 65. Just so we have it, paragraph 65 is the passages in Guardian News and Media. Effectively, he was considering himself bound to follow that approach and take the view, well, that because the law and the decision in Guardian and News Media requires me to work on the assumption that the members of the public generally understand the difference between suspicion and guilt, that box is ticked, and I effectively disregard the finding I've made that there will be members of the public who would visit awful consequences upon the applicant.
He would say it was a balance he was striking.
Well, if he could have said it was a balance he was striking, but he curiously doesn't. He makes the findings in 75, but then feels bound to disregard them because of the approach he feels required to adopt under 65. That is to say, the evidence of the specific risks has to be overridden by the general judicial view that one looks at the attitudes of members of the public generally, and that judicial view authoritatively is that members of the public generally, which is the view taken by, which Lady Justice Sharp also found herself bound to adopt, is that people understand the difference between suspicion and guilt. And that, we say, is where the analysis broke down and where he went wrong. And why, as we'll come to after the adjournment, I'm conscious of the time, it seems a convenient moment to break before I come to the Rotherham case itself, which I can take again fairly shortly.
We'll We'll rise now. You have, I think, another half hour, yes?
I think another half hour. I started a bit late, but I think half an hour should be
35
sufficient.
minutes.
Should be sufficient.
Very well. We'll resume again at 2 o'clock.
Great.
Court's now adjourned.